CREDAI-MCHI. Firstly, thank you all for making it today. I'm sure real estate as a subject is of interest to everybody. I think there is enough data points to prove to show that 85% of India's savings is in real estate. So there is nobody who doesn't get impacted by real estate in our country. This is one industry that defines the growth of the country and of 200 other allied industries. So any impact to our industry actually is impacting everybody in India directly. Just to give you certain data points for you to understand the magnitude of where real estate is today, we are the second largest employer after agriculture in India. And we all know that the whole world today is talking about creating more jobs, making in their own country. We've been making in India before the word making in India came out. So for our good and for the growth of this country, real estate has to be the center of focus for everybody. In the last 2 years, real estate created 3 crore employment, new job creations only in Maharashtra alone. If you talk about Bombay, to the corporation that actually funds a lot of the infrastructure that we are all enjoying today, we contribute close to 5,000 crores every year. That comes from only the amounts we pay for all the development that we do. Having said that, all of us are fully aligned with the mission of our Prime Minister, Housing for All. Bombay has more than 50% of the population that lives in slums. The only way Bombay can develop is by redevelopment. There is no other way because land is not available. If you look at even all the development control regulations are all skewed towards redevelopment. The whole development control regulation of Bombay is the fulcrum is redevelopment. Every section today is based on redevelopment because that is the only way Bombay can develop. Even pan-India, the way a lot of the transactions are done today are with either you purchase land, which is now far and few in between. Most of the developments are where there's a landowner and you're giving the landowner some consideration in the form of either revenue from the project or built area in the project. And the same thing in Bombay is society redevelopment that we all today are seeing in large numbers. So to just make it simple for you all to understand, there are 3 aspects of GST that impact development. One is we as developers, today we build area and give to society members or to landowners. So the area that we give them, there is a GST liability on that. Whatever rights we get as developers, there is certain amount of GST we pay at the time of completion of the project on the development rights that we get, and also all the land that we get on long-term lease from MADA, CITCO and various other planning authorities as long-term lease. The GST department treats that also as supply, and hence there's a GST liability on that as well. We have made multiple representations to every authority possible, right from the center to the state to the commissioner's level at the state GST. For us, our intent is very clear. We want to make sure that development is viable for us and hence we can provide housing at the right price to the end customer. Now in Bombay, there are 15,000 dilapidated buildings. This is the only way these people can get rehoused is if redevelopment happens. So for us, our intent is to make sure that now it's been close to 8 years since we've had GST, 7.5 years. We are all here trying to make sure that we represent our case so that we align with the overall mission of the Prime Minister to create housing for all and look at what are the gaps in the GST Act which can help make development a lot more affordable for everybody. Given that, having said that, there is a current judgment. I believe a lot of you have, I guess, covered it in some shape and form. But we've got experts here, so I'm going to hand it over to Rohit and Harsh from ELP to break it down to make you understand what exactly is this judgment and to make sure that you all have the right information that goes out to the layman also who reads everything that you'll publish.
Thank you, Sunny, and thank you all of you here. So as CREDAI-MCHI makes a statement that clearly the redevelopment is the way to go to provide housing for all. Even our Honorable Chief Minister has formed a special panel to promote redevelopment in our state. Now let's look at it. Since introduction of GST in 2017, the issues which have been cropped up under the GST regimes are very significant, and it has led to a viability of this entire redevelopment projects which the real estate developer actually carries on. So let's understand first what are the issues faced under the GST regime. A typical redevelopment project where the society gives the development right to a developer, and developer in turn then construct the entire building, effectively gives the area back to the existing members, tenants, and what is remaining thereafter, what we call it a free sale component, they sell in the open market. So the entire cost of redevelopment is subsumed in the free sale component which they sell to the customers. Now that free sale component which is sold to the customer effectively is liable to GST at 5%. So the first level of GST which comes up, that whenever that free sale component is sold to the customers, there is a 5% GST payable. No difficulty, because that's the transaction of supply of constructed flat to a new customer, and therefore they should pay GST at 5%. But at the same time, the law has been evolved in such a way that the transfer of development rights from society to the developer is also considered to be a transaction of supply of services, and there is a GST payable on that transfer also at 18%. That 18% is exempted only if you sell your entire free sale unit prior to OC. Otherwise, that 18% is liable to GST. In addition to that, developers are also required to pay GST when they give the units to the existing members, because that is how they are giving back the members their redeveloped, the revised new units, new flats. On that also, as per the GST law, you are required to pay 5% GST at a market value, that the value at which you are selling those free sale units. So that's the third level of GST. And the last one, that when the developer actually uses the material, the contractor, on that also there is a GST payable, which is not available as a credit or an offset to the developer. So if you look at it in a one redevelopment project, there have been multiple legs of transactions which have been exposed to GST, and the entire project is becoming unviable. The CREDAI-MCHI of the members first believe that when there is a transfer of development rights, it is an immovable property, because these are all rights arising out of land. Therefore, it is a transaction of immovable property. There should be no GST payable. Second, that when the area is handed over by the developer to the existing members, you cannot equate that equivalent to the sale price. It is not a sale of a unit. It is merely providing a construction services to the existing members. I am constructing a new flat for them. Therefore, how can you pay, or how can you ask the developer to pay a tax equivalent to as if it is a sale of a unit? So the two important concerns that developer have been raising before the Honorable GST Council, they have made a lot of representations, including meeting with the various finance ministers, that please address this issue, that the development rights is nothing but a transfer of immovable property, and GST ideally should not be payable on immovable property, right? And the second, that when I give the area back to members, you cannot equate this as if it is a sale units to a independent customer. This issue has been brought to GST Council notice, and CREDAI-MCHI is thankful to the Council that they have formed a group of ministers specifically deal with the real estate sector. Developer is required to pay GST under reverse charge mechanism. So there are, under the GST law, one of the, or any tax law for the purpose of any tax matters, one question which comes up is that who is liable to pay GST, right? In any tax matters, who is liable to pay that tax? Under the GST law, we have two concepts. One concept is forward charge mechanism. That means the supplier of goods or services is liable to pay tax. And one concept that we call it a reverse charge mechanism. That means the recipient of goods or services is liable to pay tax even though it is supplied by the supplier. The High Court was examining the issue that whether the developer who is a recipient of development rights is liable to pay tax or not under entry number 5B of the notification issued under the GST law. High Court has examined and said that 5B is not applicable, which is itself has not looked at it all the provisions, which is still not the complete in terms of the decision making. We have to bring to the notice of High Court some of these other provisions of the GST law. But High Court in Nagpur bench has held that under reverse charge mechanism, no GST payable. That means the fallback position is that it is payable under forward charge mechanism. That means it is payable by the society. But that's not the correct GST provisions today. High Court has to reconsider their judgment, and I am sure that when this issue comes up before the Bombay bench or other benches, this issue gets clarified.
So basically we are standing where
We are at the status quo.
We are aware.
So there's nothing.
Nothing changed. Nothing changed. Yes, please.
Sir, I just wanted to understand something just so that we are on the same page. So there are two transactions that happen. One is the JDA where the homeowner is the one selling the development rights, and the other is the construction services. So the JDA is done on an RCM basis, correct, right? And the
Construction services is on the
FCM.
forward charge basis.
Yeah, so both the RCM and FCM are paid by the landowner or homeowner.
Developer.
Both are paid by the developer.
Both are paid by the developer, but as we all know, it is an indirect tax,
Okay.
which has to be passed on to the ultimate consumer. See, first of all, we should understand the GST is a consumption-based levy. The tax has to be borne by the consumers.
Yes, so why is the developer liable to pay the...
So let me just break this into two parts for your simple understanding. Let's say today all of you are members of a society, all of you have your individual apartments. As a developer, you all appoint a developer and give a development right. It's called a development agreement. What are you giving the developer? You're giving development rights to construct, so that I give you your flats and I sell some flats to third-party customers. So what have you given the developer? Development right. On this development right, on reverse charge basis, which means me, in spite of being the receiver of the service, on reverse charge, we are supposed to pay GST once the project is completed. So that's one point, which is the subject matter of this court order, whether under reverse charge, is the developer liable or not? That is what is being discussed in this order. So one levy is society giving the development right to the developer, so that is still taxable. There is no relief in that tax. Now we are talking about we giving society members the apartments that they own. So you own, let's say, 1,000 square feet, you got 1300 square feet. On that 1300 square feet, at market rate, at the rate at which I sell, I'm supposed to pay GST at the rate of 5%. Now, if you just as layman understand this, you already own 1000, so I have not sold anything to you. That 300 extra that you are getting to make it 1300 is by the regulation. I have to give you that area as per the regulation. So what am I doing for you? I'm only constructing for you. And when I'm constructing for you, on the construction cost, material, labor, contractors, I'm paying GST. All of this is part of my cost when I'm charging the end customer, and the end customer is also paying 5%. So what the department is saying that I gave you 1300 square feet, they are not today understanding that this was anyways yours. All I have done is constructed for you. They are assuming I have sold this 1300 square foot to you at 40,000 rupees a square foot, and hence they are saying now you pay 5% on your area also. But I never sold any area. I was building this for you so that I get some area to sell. All of that got bundled in the cost I charge the end customer. Correct? So the first leg to reiterate is society giving development right to the developer, on which we are supposed to pay GST under reverse charge when the building is completed. Second leg of service that they are assuming is what I give as a developer to the society members in terms of the area I give you, and that is taxed at what? Your area in the new building into my selling price into 5%. Now this is leading to double taxation, and over and above this I am paying on the material labor that whatever I am constructing, the actual construction cost for giving contractors, buying material, on all that I am paying GST, and there is zero set off. We get no set off in real estate because what I charge the end customers at 5%, all of that goes to the government. So you look at the different levels of tax. I give you all area as a society member, I pay tax on that. On the entire material and labor that I spend on for making the building, I pay at 18% or 28% on that. Whatever I am charging the end customer 5%, all of that is going to the government. So there are three levels of taxation, which is what we have been trying to make them understand, that this is inflating the cost artificially, and this is what we should get rationalized.
So just to clarify, the society wala themselves, even if I am going for redevelopment, am I paying GST on any of the levels?
So today, no society member obviously themselves in many cases can afford or will not pay. They expect the developer to pay, and anyways the developer has to pay on reverse charge basis.
So you are right, just to make it clear, there is a concept of statutorily who is liable to pay tax to the government, and then other concept is who is taking the burden of that tax. So statutorily, developer is liable to pay tax to the government, but because it is part of the indirect tax levy mechanism, on the flat which is given to the society members, they are the consumers of that flat. Generally, that 5% then should have been passed on to the society members, and society members should pay 5% on that redevelopment flat that we get, which is a new flat, which is being given by the developer, and that too as per the GST law at the market value of that flat. Now the question is, can these society members, when they are entering into a redevelopment, afford to pay this 5%? One is, it is a depalliated building, it is necessary for to go for redevelopment, and at the same time government is expecting that this developer pays that 5%, and in turn, because it's a consumption based levy, society members should pay that 5% at a market value. So let's take an example. I live in a small apartment in a Bombay of 300-400 square feet, or a 1 BHK apartment. That 1 BHK apartment is going for redevelopment. Average square feet area in Mumbai, a reckoner price is also 20-25,000 rupees a square feet. On that 25,000, 800 rupees a square, 800 square feet of flat, it costs us 2 crore rupees. On that 2 crore rupees, 5% is 10 lakhs rupees GST. And while it is liable to be paid by the developer, it is expected that the society members should reimburse that 10 lakhs. When I am staying in a 1 BHK apartment of 500 square feet and it is going for redevelopment because building has become old, do I have a 10 lakhs to pay that cost?
So that
I don't
is,
have that money to pay the 10 lakhs rupees.
so that is not priced in anywhere.
That is not priced. And that is the real problem. That we are saying that don't ask us to pay that tax at 25,000 or 30,000 rupees a square feet, which is a regular price. What am I doing for you? I am only constructing this apartment for you, right? At the best, whatever is the construction cost, on that we cover GST. But how can you ask me to pay at a market value 5%, in this example of 10 lakhs rupees, additional GST, plus developer, as Sunny explained, also paying GST on all the cement, steel, the labor, all of them they are buying. So how many times in a one redevelopment project there will be a GST?
Sir, I just one question. You have been engaging with the GST Council. So what are they saying? I mean, don't they see the...
They have understood this problem. They have already formed the group of ministers. Any GST council, the process works is that any issue is brought to their notice, they form a group of ministers to decide this issue. But unfortunately, this group of ministers has been deliberating. It has been months, in fact years. We are still awaiting the decision.
We've been told that this issue is under consideration as we speak, but we haven't heard anything formal from the council or the group of ministers.
In the redevelopment building, there are old tenants and new tenants also come. So charges, the GST is common for both.
Common for both.
Yes.
That is the entire issue.
It should not be.
It should not be the new
So they will also
members.
equating both as same.
New members who is in my example paying 25,000
They should
rupees
not be treated at par.
at par. That's our entire issue.
I am going there because of my difficulty.
Yes.
The person those who are purchasing new one, they should have tax
They
more.
have that buying power to buy and they can possibly, afford that GST, which all of us as, agree and appreciate that should be charged. But the issue is about existing members who's already living in a building which is not in the best of the condition and the GST impact on that.
So that's the idea. This has a larger social impact, which is what we are trying to make the government understand.
डिस्कस कर रहे हैं वो है एक बॉम्बे हाई कोर्ट नागपुर बेंच का एक रीसेंट जजमेंट जो श्रीनिवासा रियलकॉन का है, जो डेवलपमेंट राइट से रिलेटेड है, जिसमें लैंड ओनर या सोसाइटी एक डेवलपर को डेवलपमेंट राइट देती है। मुद्दा ये है कि जो जीएसटी की एप्लीकेबिलिटी है वो रिवर्स चार्ज पर है या फॉरवर्ड चार्ज पर है। रिवर्स चार्ज का मतलब ये है कि जब डेवलपर वो खुद एज अ रिसिपिएंट ऑफ द सर्विस डेवलपर वो जीएसटी लाइबिलिटी डिस्चार्ज करता है, उसको रिवर्स चार्ज कहते हैं। और फॉरवर्ड चार्ज है कि जो सर्विस दे रहा है वो ये लाइबिलिटी डिस्चार्ज करता है। तो ये पूरा जो मुद्दा है इस बेसिस पे निर्भर है कि जो लाइबिलिटी है वो रिसिपिएंट की है या गिवर की है। और हमारे साथ हमारे एक्सपर्ट पैनलिस्ट मिस्टर रोहित जैन और हर्ष हैं ELP से, तो वो आपको इस पर थोड़ी और डिटेल में बात करेंगे।
ये देखिए, GST इम्प्लीकेशंस एक रीडेवलपमेंट प्रोजेक्ट के लिए बहुत बड़ा मुद्दा हो गया है। जब से GST आया है 2017 से, GST ये रीडेवलपमेंट प्रोजेक्ट्स पे ट्रिपल इफेक्ट इज़ व्हाट इज़ वी कॉल इट, जहाँ लग रहा है। एक तो सोसाइटी जब डेवलपमेंट राइट्स डेवलपर को देती है उस पे GST लग रहा है। जब सोसाइटी मेंबर्स को डेवलपर एरिया देता है उस पे GST लग रहा है। और जो डेवलपर पूरा बिल्डिंग कंस्ट्रक्शन करने के लिए जो पूरा सीमेंट, स्टील और लेबर एम्प्लॉय करता है, डिप्लॉय करता है, उस पे भी GST लग रहा है। इसलिए ट्रिपल इफेक्ट हो गया है GST का। पूरी डेवलपर, पूरी रियल इस्टेट कम्युनिटी, MCHI, CREDAI, ये जो मुद्दा है ये GST काउंसिल पे रिप्रेजेंट कर रहे हैं। GST काउंसिल ने ऑलरेडी ग्रुप ऑफ मिनिस्टर्स फॉर्म किए हैं। ये मुद्दा उनके सामने ऑलरेडी रखा गया है, वो एग्जामिन कर रहे हैं। बट मीनवाइल ये असेसमेंट जीएसटी की चालू हो गई है, बिकॉज जीएसटी आके आज 7 से 8 साल हुए हैं और जीएसटी के असेसमेंट चालू हुई है। जीएसटी अथॉरिटीज़ जब असेसमेंट कर रहे हैं तो उसमें शो कॉज नोटिस इशू कर रहे हैं, डिमांड इशू कर रहे हैं, एंड बिल्डर, डेवलपर और द सोसाइटी मेंबर्स आर वेरी कंफ्यूज्ड कि इसमें जीएसटी लगेगा कि नहीं लगेगा। ग्रुप ऑफ मिनिस्टर अभी भी डिसाइड नहीं किया है फाइनली। इसके लिए कोई डेवलपर ने ये मुद्दा हाई कोर्ट में लेके गए, एक रिट पिटीशन फाइल किया था। ये रिट पिटीशन बहुत सारी हाई कोर्ट बेंचेस में अभी भी पेंडिंग है, ये अभी भी डिसाइड हुआ नहीं है। एक रिट पिटीशन एक श्रीनिवासा रियलकॉन के केस में नागपुर बेंच ऑफ बॉम्बे हाई कोर्ट के सामने आया। उन्होंने जब मुद्दा डिसाइड किया, उन्होंने एक ही मुद्दे पे डिसीजन दिया है कि इस पे रिवर्स चार्ज पे जीएसटी लगेगा या नहीं लगेगा, और उन्होंने डिसीजन दिया कि रिवर्स चार्ज पे नहीं लगेगा। इसका मतलब ये नहीं है कि जीएसटी नहीं लगेगा, जीएसटी तो लगेगा ही। आज जो लॉ है इसके हिसाब से डेवलपमेंट राइट्स पे भी जीएसटी लगेगा, और जो एरिया मेंबर्स को दिया जा रहा है उस पे भी 5% जीएसटी लगेगा। ये जो मुद्दा है, ये जो मसला है, एक तो बाकी हाई कोर्ट बेंचेस जब डिसाइड करेगी या जीएसटी काउंसिल उस पर कुछ अपना निर्णय देगी तो ही ये क्लियर होगा। तब तक जीएसटी लॉ के तहत इस पे जीएसटी लगता है और जीएसटी भरना पड़ेगा जब तक ये आगे की क्लैरिटी नहीं आती है।
सर, आपसे जानना चाहूँगा, जैसे सर ने कहा कि जीएसटी भरना पड़ेगा, तो एक डेवलपर के ऊपर भी एक प्रेशर आता है उस चीज़ का, तो व्हाट डू यू थिंक, वो जीएसटी क्या सोसाइटी मेंबर्स को पे करना चाहिए या फिर डेवलपर्स को ही बेयर करना चाहिए?
कोई भी टैक्स लॉ में 2 कंसेप्ट्स रहते हैं। एक कंसेप्ट होता है कि गवर्नमेंट को भरने की जिम्मेदारी किसकी है। ये जो ट्रांजैक्शन हमें डिस्कस कर रहे हैं उसमें गवर्नमेंट को टैक्स भरने की जिम्मेदारी डेवलपर पे आती है, आइदर अंडर रिवर्स चार्ज या जब यूनिट्स एग्जिस्टिंग मेंबर्स को हैंड ओवर करते हैं उस पे अंडर फॉरवर्ड चार्ज मैकेनिज्म। बट जीएसटी एक कंजम्पशन बेस्ड टैक्स है, जिसका मतलब ये होता है कि इवेंचुअली ये टैक्स का बर्डन जो फाइनल कंज्यूमर है उस पर पास ऑन होते रहता है वन लेवल टू अनदर। अगर हम उस लॉजिक को एक्सटेंड करेंगे तो ये जो सोसाइटी मेंबर्स को अल्टीमेटली जा रहा है, एंड आज का कानून ये कहता है कि जो एग्जिस्टिंग सोसाइटी मेंबर को भी यूनिट मिलता है उस यूनिट पे भी मार्केट वैल्यू के दाम पे टैक्स भरना है, ना कि कंस्ट्रक्शन कॉस्ट पे। उस लॉजिक के बेसिस पे जाएंगे एंड कंजम्पशन टैक्स, जीएसटी बीइंग एंड कंजम्पशन टैक्स, तो ये कॉस्ट टेक्निकली सोसाइटी मेंबर्स ने बेयर करना आना चाहिए। बट हम ये पूरा मुद्दा समझते हैं कि इसमें सेंसिटिविटीज़ है, बॉम्बे जैसी प्लेस में इसका रेट्स काफ़ी हाई है। इसी के चलते हुए जीएसटी काउंसिल से CREDAI-MCHI थ्रू अस एंड अ लॉट ऑफ अदर पार्टनर्स हम यही कोशिश कर रहे हैं कि जल्द से जल्द इस मुद्दे का हल निकाला जाए।
थैंक यू सर।